Filing bankruptcy in Ontario. Third time should not be a charm. Introduction. We have all heard the expression, third time's a charm, or third time lucky. You say this when someone is successful the third time they try something after they failed the first 2 times. This expression is not meant to apply to the world of Canadian insolvency. Certainly not for filing bankruptcy in Ontario. On December 9, 2019, the Toronto Star published an article by investigative reporters Jesse McLean and David Broussard titled Rack Up Debt, Declare Bankruptcy, Repeat and Repeat Again, How Thousands of Canadians Are Doing It and Costing the Rest of Us. The article talks about 4 specific people who have filed for bankruptcy multiple times. In this Brandon's blog, I want to describe how the bankruptcy process in Ontario and Canada works. Thankfully, the article does state that in the Toronto Bankruptcy Court, it is much tougher to get away with multiple bankruptcies, as it should be. How do I declare bankruptcy in Canada? Filing bankruptcy in Ontario begins with a no-cost consultation with a licensed insolvency trustee, formerly called a bankruptcy trustee. In that consultation, the trustee will want to get a good understanding of your assets, liabilities, income, and expenses. That way, the trustee will be able to discuss with you all the available options and help you narrow them down to the most viable options to solve your debt problems. At the end of the meeting, the trustee will give you the standard intake form. By completing the form fully, you will provide the trustee with the proper information needed for your filing bankruptcy in Ontario. My firm calls our standard intake form the Debt Relief Worksheet. The trustee then takes the fully completed worksheet and all additional documents in support of your information. The information is then used in order to prepare the documentation necessary for filing bankruptcy in Ontario. The documents include your statement of affairs and your statement of income and expenses. The statement of affairs used for filing is attested to by the debtor as to its accuracy. This statement includes a listing of all the person's assets and indicates which are exempt from seizure and which are not. The asset exemptions are guided by provincial law. As there are some variations between provinces, in this blog I will only be referring to Bankruptcy Ontario exemptions. The assets not exempt from a seizure will be surrendered to the trustee to be sold. The statement also lists all the names of the creditors, their respective addresses, and the amount owed to each. The statement of income and expenses, as the name suggests, shows the monthly income and expenses of the household. It also shows whether or not the person will be subject to surplus income payments to the trustee or not. When all the documents are ready, the trustee electronically files them with the Office of the Superintendent of Bankruptcy. The local OSB representative reviews the filing. If everything is in order, the OSB issues a bankruptcy certificate. The issuance of that certificate is the moment the person is now bankrupt. How long does bankruptcy last in Ontario? The Canadian bankruptcy system is administered under the Bankruptcy and Insolvency Act, Canada. This is a federal statute. So the question is not how long does bankruptcy last in Ontario, rather it really is how long does bankruptcy last in Canada. The Toronto Star investigative article talks about the length of a bankruptcy. It correctly states that a first-time bankrupt that does not need to pay surplus income is entitled to an automatic discharge after 9 months. This assumes that they have lived up to all of their commitments as an undischarged bankrupt, as well as completely cooperated with the trustee. If a first-time bankrupt has surplus income, they must pay it for 21 months prior to qualifying for a discharge. This again assumes that they have fully cooperated with the trustee. In both cases, if neither the trustee nor a creditor opposes the discharge of the bankrupt, the trustee can issue the discharge certificate. In a second-time bankruptcy, with no surplus income, the bankrupt has to wait for 24 months before being eligible for a discharge. Again, if the bankrupt has completed all duties and has cooperated fully, and no creditor opposes the discharge, the trustee can issue the discharge certificate. If there is a surplus income requirement, then the minimum period before being eligible for a discharge is 36 months. Under the same conditions, the trustee can issue the discharge certificate if there is no opposition. The article highlights, correctly, that if it is the person's third or more bankruptcy, the trustee cannot issue a discharge certificate. The discharge hearing must be held in court, even if the trustee is not opposing. The reason for this is because the Canadian bankruptcy system is supposed to financially rehabilitate the honest but unfortunate debtor. So in a third or more bankruptcy, the court wants to review the circumstances of the person's bankruptcy and why rehabilitation has not been accomplished yet. If there is a trustee or creditor opposition to discharge, the hearing becomes more complicated. I have written several blogs previously on the bankruptcy discharge process. How bankruptcies work in Canada, multiple times. The investigative reporting in the Toronto Star details the multiple bankruptcies of 4 different people. These people range from being in their 3rd to 5th bankruptcy. The article states that the province of Quebec has the most people who have gone bankrupt multiple times. The article, of course, and rightly so, takes a very dim view of people who game the system with multiple bankruptcies. As I mentioned earlier, the article clearly states that from their research in Ontario and Quebec, the writers found that the Toronto Bankruptcy Court takes the dimmest view of people with multiple bankruptcies when they come up for their discharge hearing. Being a serial bankrupt is not a good thing. The reporting is fair and balanced. It does admit that some people just get a curveball thrown at them in life and have no choice but to file for bankruptcy in Ontario. However, there are 2 themes stressed in the article which I don't think are accurate. They are: unpaid taxes owed by repeat bankrupts make up a portion of the nearly $4 billion the Canada Revenue Agency has written off since 2009 because of consumer and commercial insolvencies. In Quebec, the provincial tax agency has lost nearly $2 billion to insolvencies in the last 5 years alone. While this is true, it assumes that the taxes would have been paid if the people did not file for bankruptcy multiple times. My belief is that people who go bankrupt multiple times have their affairs arranged in such a way that they do not have much to lose in bankruptcy. If they don't have much to lose in a bankruptcy, then there isn't much for CRA to seize if the person is not bankrupt. So the reality is that there is a class of Canadians that will not pay their fair share no matter what. This is clearly unfair to society as a whole, but it isn't bankruptcy that causes it. Meanwhile, credit card lenders absorb the cost of bankrupts who do not pay their bills by charging high interest rates to their customers who do pay their debts. I believe the fact that credit card companies charge high interest rates is obviously true. However, in my experience, customers who do pay their credit card debt are not incurring interest charges. They pay their monthly credit card balances off monthly. Those who only make the minimum payment are the ones who are incurring high interest charges. Ultimately, those people cannot afford to make all their debt payments, and they ultimately invoke an insolvency process, being either a consumer proposal or bankruptcy. So even a one-time only bankrupt pushes a loss onto a credit card company, hence the high interest rates charged. By the way, Who is it that makes the credit decision to extend new credit to a multiple-time bankrupt? It isn't the bankruptcy system. It is the credit card issuer. Perhaps they should not give a credit card to someone who has demonstrated many times that they cannot handle the credit responsibly. Filing for bankruptcy in Ontario. Rack up debt. The statistics quoted in the article shows that although there has been an increase over the years in multiple-time bankrupts, this is somewhat of a self-fulfilling prophecy. By definition, if a certain segment of the Canadian population goes bankrupt multiple times, then the statistics have to show an increase. The statistics used in the article shows the following regarding the percentage between first and second plus out of total personal bankruptcies between 2011 through 2018. My takeaways from these statistics are: personal bankruptcies in Canada dropped by 29.4% between 2011 and 2018. I believe there are two main reasons. First, fewer Canadians are opting for an insolvency process in an era of unprecedented low interest rates. Second, those requiring an insolvency process have sufficient income to perform a successful consumer proposal, thereby being able to avoid bankruptcy. The increase in second and more time bankrupts is just under 5%. I believe most of the increase is, as mentioned above, somewhat self-fulfilling. Every time the same person goes bankrupt, the statistic has to increase. So, what percentage increase is because of the actual mathematical formula, and what percentage increase is because there are actually more people in raw numbers are filing for bankruptcy more than one time? Summary. I hope you found this Brandon's blog on filing for bankruptcy in Ontario useful. Sometimes things are too far gone and more drastic and immediate triage action is required. Do you have too much debt? Are you in need of financial restructuring? The financial restructuring process is complex. The Ira Smith team understands how to do a complex restructuring. However, more importantly, we understand the needs of the entrepreneur or the person who has too much personal debt. You are worried because you are facing significant financial challenges. It is not your fault that you are in this situation. You have been only shown the old ways that do not work anymore. The Ira Smith team uses new modern ways to get you out of your debt troubles while avoiding bankruptcy. We can get you debt relief freedom. The stress placed upon you is huge. We understand your pain points. We look at your entire situation and devise a strategy that is as unique as you and your problems, financial and emotional. The way we take the load off your shoulders and devise a debt settlement plan, we know that we can help you. We know that people facing financial problems need a realistic lifeline. There is no one-solution-fits-all approach with the Ira Smith team. That is why we can develop a restructuring process as unique as the financial problems and pain you are facing. If any of this sounds familiar to you, and you are serious in finding a solution, contact the Ira Smith Trustee and Receiver Inc. team today. Call us now for a free consultation. We will get you or your company back on the road to healthy, stress-free operations and recover from the pain points in your life, starting over, starting now. Filing Bankruptcy.
I hope you enjoyed the video. The Ira Smith team is available to help you at any time. We offer sound advice and a solid plan for starting over, starting now, so that you'll be well on your way to a debt-free life in no time. For more information on a no-cost basis, please visit our website or call us. Our website and telephone details are coming right up now.